Yeah.
Every now and then, that's his own. All right, this is case number 16-105-424. This is Community Alliance Credit Union versus Ellen Milford. Mumford, I should say. On the matters before the court on the application for a subpoena. Your appearance for community.
Good morning, Your Honor. Elizabeth Butler, P809564 for Plaintiff Community Alliance Credit Union.
All right, thank you, Ms. Butler. Good morning to you. I'm looking to see whether I have Mumford on this Zoom. Ellen Mumford, if you're on this Zoom, please say something at this time. All right, I see where there is information provided that the respondent was in fact served with the subpoena. Is that correct, counsel?
Yes, Your Honor. She was personally served on August 16th, 2022.
All right, thank you, counsel. It appears now that the respondent has not appeared as directed to do so. Your pleasure at this time, counsel.
Your Honor, I don't know what this court's opinion is on bench warrants. I would be guided by your typical procedure on a show cause or a bench warrant.
Yeah, that's the right way to approach it for sure. All right, we're gonna go ahead and set it up for a show cause. The show cause date in this matter. I'll give that to you for just a moment.
What do you want it? You gotta go, you have like October and you have November.
Yeah, I set it up late October, mid-October.
You want 19th, October 19th.
October 19th is going to be the date, 10/19/22. I'm going to set that on at 9:30 a.m. That will be the hearing on the petition to show cause. So if you'll get those items over to us and I'll sign off on it. I'm going to give you an email address where you can send that to, and then we can get that on right away. That's Latifah, LATIFA@3636036districtcourt.org.
36thdistrictcourt.org.
That's correct.
Thank you, Your Honor. I have it.
All right. Good day to you, and we'll get that all signed off as soon as you get the paperwork into us.
Thank you, Your Honor. You have a great day too.
Likewise. The court now calls case number 21-142-895. This is Oakland Community College versus Alexandria Dixon. The matter is before the court on an application for a subpoena that was issued in this matter. Today is date time set for hearing in that regard. Your appearance for Oakland Community College, please. For Oakland Community College, do I have Alexandria Dickerson on this Zoom? All right, the court will pass on that matter. It does not appear that either side has appeared on this matter. Accordingly, I should indicate at this time that the subpoena will be set aside. The court now calls case number 22-179-438. This is Earl Gray versus Elmhurst Home Incorporated. The matter is before the court, set on for a first hearing status conference regarding this matter. Do I have Earl Gray regarding this matter?
Yes, I'm here, Your Honor.
All right, good morning to you, Mr. Gray. Thank you. For Elmhurst Home Incorporated, your appearance at this time? Elmhurst Home Incorporated, your appearance at this time? Just one moment here. right, I received a document from the Elmhurst Nursing Home signed by Miss Betty Smith. But I don't have anything showing an appearance by an attorney in this matter. And in order for the plaintiff, strike that defendant to proceed, given that they're an incorporated entity, they would have to have an attorney involved in this matter. So is anyone here for Elmhurst? All right, so it appears that no one has appeared in regard to the Elmhurst home. So, sir, what is this case about in 100 words or less?
I was discriminated against by this company in several ways, and that's short and sweet.
All right, so you took it to the appropriate agency. They did not give you a right to sue letter. Is that correct?
They did so give me a right to sue.
All right, I'm looking at the document that was sent to me that indicates that it was that your petition in front of that agency was dismissed. Is that correct?
I could be mistaken. I have another situation going on. I could be mistaken, but I believe they told me to proceed how I saw fit. They didn't. I can't really recall whether they gave me permission to or not.
All right, just one moment. Let me just see. Let me look at a document that was sent to me from where you brought a charge of discrimination. Let me see. Let me just take a quick look and see what happened.
I mean, I'm on my phone right now, but I would have to check my emails to be sure about it.
Right, I got you. Just 1 second. It won't take but a moment. Look at it. All right, I've looked to see whether or not any of the paperwork that was sent in from the plaintiff, sorry, the defendant, claims that the matter was dismissed, whether there's any supporting documents along that line. I don't see anything.
Right, because I don't believe it was dismissed.
Don't interrupt me while I'm talking. All right, so I don't see anything in that regard. And I don't know why the defendant is not here or did not have an attorney present at this time. So what I'm going to do is I will enter a default for the defendant's failure to appear. I'm going to set a hearing. I'm going to set a subsequent hearing on this matter, give them a chance to show up on the issue of any damages that might be issued regarding this matter. But defendants are in default, or the defendant corporation is in default for failure to appear on today's date. I will allow their appearance for purposes of determining whether or not there are damages in this case. I'm setting a hearing date in that regard. That date,
Well, 10/19, 10/19.
maybe not that far off. We can,
Okay.
you wanna put it in the end of this month. October the 4th. 10/4/22 at 9:45 a.m. is going to be the next action date in this matter. So you'll need to show up at that time. We're going to send a notice out to the other side indicating that a default has been entered and that someone must appear on that date. And I'll address any issues that need to be addressed at that time. So, all right, that's 10/4/22 at 9:45 a.m. You will get a notice in the mail to be back on the Zoom on that day, sir. Good day to you.
Yeah, all right.
All right, this is case number 22-180187. This is Midland Credit Management versus Markeisha Hamilton. The matter is before me for a status conference. It appears that I did receive something that is styled as an answer in regard to this matter. It appears the matter is before the court, wherein the plaintiff seeks to collect on a indebtedness of $1,533.94. Your appearance for Midland, please.
Hi, good morning, Your Honor. Stephanie Petway, P64543, appearing on behalf of the plaintiff.
All right, thank you, Ms. Petway, and good morning to you, ma'am. I'm looking now for Markeisha Hamilton. If you're on the Zoom, please say something at this time.
Good morning, Your Honor. I'm here.
All right, thank you, and good morning to you as well, Ms. Hamilton. All right, so have the two of you talked about this at all, Ms. Petway, if you will?
Yes, Your Honor. We did have an opportunity to speak in a breakout room this morning. And at this time, the parties are just requesting a little bit more time. The defendant admits the debt. However, she's currently unemployed. She wants to speak with her fiance to see what their finances are looking like before she commits to a payment plan or anything of that nature. I also explained to her that my client has a hardship program. So if they're not in a position to be able to start payments now, we could give her a little more time. So given that information, I believe it would be appropriate to give us a short adjournment, see if the parties can work something out on their own accord before the next court date.
Ms. Hamilton, that makes sense to you, ma'am?
Yes.
All right, so why don't I go ahead and set this over for October 4th,
Okay.
and I'll take a look at it. I'm going to go ahead and set it on at 9:45.
Okay.
So 10/4, and I'll set it for review on that date, and let's see where we are.
Okay.
We'll take a look at action. All right.
Thank you, Your Honor.
Thank
4 at
you.
9:45 a.m. All right, good day to the two of you.
You as well. Bye-bye.
The board now calls case number 22-182520. This is Coolidge Imaging LLC versus City of Detroit. The matter is before the court, set on for a pretrial conference regarding this matter. Your appearance for the plaintiff, please. For Coolidge Imaging.
Good morning, Your Honor. Ryan Jernigan for the plaintiff, P83482.
All right, thank you, Mr. Jernigan. Good morning to you, sir. All right, for the City of Detroit, your appearance at this time, please.
Good morning, Your Honor. Christopher Michaels, P83156 on behalf of the City of Detroit.
All right, thank you, Mr. Michaels, and good morning to you as well, sir. I know that on a previous occasion, I did issue an order for a scheduling order in this matter that basically addressed the issue of discovery, and then we set it for review on today's date. So how far along are you? Anything needed further from the court? Any possible resolutions? Somebody talk to me right now.
Well, Your Honor, the City of Detroit has actually filed a motion to compel discovery as well as a motion for summary disposition in this case. So I don't know if this court wants a, good.
And looking through the file, I do see the motion for summary disposition. I don't see the motion to compel, but then let me take just another bit of a look here. And Mr. Jernigan, did you file a responsive pleading to that motion for summary disposition, sir?
Yes, Your Honor, I did file a response to the motion for summary disposition. And I believe also Mr. Michaels has a copy of our response as well. I believe he also filed a supplemental response to that as well. And then in regards to the motion to compel, I believe a lot of the issues, council would agree, kind of overlap. So I don't know if you want to address the MSD first or.
Yeah, I want to, the first thing I want to do is to see whether or not you've been able to resolve the issues as it relates to discovery in this matter. I do see the motion to compel answers to discovery requests. It looks like, just one moment here. It looks like I see plaintiff's response to City of Detroit's interrogatories and request for production documents. All right, so let's drill down on the discovery issues. Is it conceded at this point that those issues have been resolved, Mr. Michaels?
No, Your Honor. The only thing that has changed is plaintiff's counsel did provide a signature, which was required by the statute, and did provide a response. So I think it was request 20, identifying the claimant. They provided a copy of his license, but Mr. Jernigan has not supplemented his responses at any point. So at this point, and considering the city filed its motion because a lot of its motion for summary based on the complete lack of any admissible evidence.
Yeah.
And
Your Honor, if I could,
We'll get to the motion for summary disposition. But what would satisfy the discovery request at this time? It seems like there was some supplementation by way of providing identifying information and signatures. What else is missing by way of the request for discovery?
Your Honor, it's pretty much the entire discovery is boilerplate terms. The plaintiff doesn't provide. I mean, it's not that I'm not asking for every record that ever existed in there. I'm asking for such simple things as a copy of the CV of witnesses, or a copy of the medical license of the treating physicians, the certificate of need that the facility is required to have. Itemized, and also a lot of it goes into how their rates are determined. They merely object that it's vague, irrelevant, and use boilerplate objection terms. So it's really the entire case, it revolves around how they determine their rates, and they refuse to provide any information whatsoever, calling it unduly burdensome.
Your Honor, if I may, I'd like to argue the motion to compel and go over that if we could, because we tried to, go over, and I tried to provide what was necessary for discovery, and we tried to work it out. So I'd like to go over the motion specifically, go over the points that he addressed in his motion.
Well, there's no problem with that. I mean, the point of the matter is that the court has, in the interest of efficiency, the court has asked the parties to simply drill down on what the issues are.
Sure, and that's what our motion.
I've probably heard 150 or 200,000 motions in my time. I don't want to go through minutia. If smart attorneys know what the key issues are, and if you can drill down on them, then that would certainly be helpful. But whichever way you want to proceed on this, it seems that it seems that the defendant city is saying that there has been a complete lack of any forthcoming of basic information that would be crucial to the advancement of this cause. And so, Mr. Jernigan, I think it's on you to respond to it and tell me what's going on here, sir.
Yes, thank you, Your Honor. I would agree. So let me bring up their specific motion. Some of the points that defendant raised right now, he raised in his motion specifically, he's referring to the service providers, my client provided MRIs. So he asked for the medical license of the providers. That's public information. He can look up on him. He can look up himself. That information is public knowledge. You can look that up. Another request he asked for the certificate need of my client. That information is also public knowledge on LAR.
I didn't hear the second thing you asked for.
I'm sorry. Let me bring it up. That's why I said I want to go over every point because we're not. Yeah, he asked for their certificate of need for my client, which is available on the LAR. That's public information they can look up on the internet as well. A lot of the information that he's requesting is information he can simply look up himself. The main issue he addressed in his supplemental response, he says we didn't address anything as far as the reasonableness of our rates. He never asked about that specifically. All he did is inquire about the medical rates. Our client would be happy to answer how they determine their rates were reasonable and provide all the necessary documents to that effect as well, but they never inquired about that. Like I said, we had a conversation about it. I wasn't trying to be difficult. I'm trying to provide all the necessary information, but a lot of information that they asked for is simply information they can discover themselves or questions they didn't specifically ask. Another thing he asked for, the resumes for all our experts. I said we'd be happy to do that if we go to trial when that's appropriate. We provide all our expert witnesses. Like I said, a lot of the things I tried to work it out. So I felt we needed to get the court's ruling on these specific issues.
All right, thank you, counsel. Mr. Michaels?
To respond, begin with this idea that medical licenses are publicly available doesn't alleviate their need for providing discovery responses, but I guess as a matter of for this court's information, that I did look up Priyesh Patel as one of their doctors, and there are 3 listed Priyesh Patels, one with an expired license, and I have no way of knowing which one is supposed to be the Priyesh Patel that was providing treatment. Their second doctor was Dr. Alkius Lapis, who I looked up his medical license just as counsel recommended, and there is no listed Dr. Lapis. So the idea that it's just publicly available and I can find it first doesn't alleviate their, and also to the certificate of need that they would say the city should just pay and go find it publicly. The point of discovery is to have they have access to the certificate of need. I have requested it. Just because it can be gotten from a third party does not alleviate their responsibilities under the discovery rules. As to the CVs, I also asked for the CVs of their biller, and they just simply refused to provide it. I also asked them to provide the name of any witnesses who can test to the reasonableness of their rate. They objected. They seem to have only they'll provide the experts, they'll provide witnesses later. That discovery and this court ordered discovery, and they just do not want to respond to discovery and say the city should just look it up themselves, and they refuse to provide any discoverable information. Furthermore, lastly, the city did ask about how much do they charge to third parties, and I notice how the plaintiff counsel doesn't address this. This is critical information. It is reasonable and it is discoverable. There's Court of Appeals cases indicating that I can ask about how much they charge and accept from third parties, and also the costs they incur in providing services. They just outright refuse to provide this discoverable information. So this is a matter of really an attempt of trial by ambush by plaintiff. They'll say, we'll get you experts. You can depose people later. We'll get you this information. It's publicly available. They merely just don't want to participate in discovery, want the city to incur more expenses to get information which is readily accessible by plaintiffs.
Your Honor, if I may, that is not accurate. Our discovery responses specifically list plaintiff's proposed witness lists. We specifically list witnesses by name, not a building or a business. We specifically name who set our rates. We refer to them in our discovery responses, Your Honor. So we're not trying to ambush them. And those are, if the trial started today, those would be the same people that we would produce and be expected for trial. So it's not trial by ambush. That's inaccurate statement, Your Honor. They are clearly listed. It lists names of people.
Which discovery response number is this? I'm sorry.
Sure, let me pull it up. It's So, Your Honor, if you look essentially at the very beginning on the second page of our discovery responses, plaintiff's proposed witness list, and it lists specifically, like I said, the biller is listed by name, the billing services, all the doctors specifically by name. I could go on, Your Honor.
Well, okay, I think I've heard enough on the motion. I have not heard anything that's been requested or demanded by way of discovery, and that has been set forth in the motion that is not discoverable information. And I really, I hate when parties find themselves bogged down on discovery issues, because there's, there are bigger issues to get to in terms of trying to resolve the case. But certainly, I don't care. I guess that's less than a polished way of putting it, that information might be available in the public somewhere. The fact of the matter is that when you participate in a litigation process, the extent to which the request is set forth in some discovery document, you have to respond to that. It makes it in the interest of efficiency and moving forward, where there are person documents, information that is under the party's control that has brought the action before the court. They are to submit that information. Otherwise, we get bogged down in discovery. And that's what is beginning to happen here. The information that Mr. Michaels has requested, that has been set forth, that Mr. Jernigan has set forth as the specific issues that have been raised in this matter. I don't see any of those issues where there should be any objection raised as to presenting the items requested in the context of discovery. Mr. Jernigan has also indicated that as relates to rates and the calculation of rates, that they're prepared to provide that information. That is a reasonable thing to do. The other information as well. All of the, I don't see anything in the discovery request that should not be provided in the context of this case, as it relates to witnesses that might be used, information, background information regarding those witnesses, et cetera. That information is discoverable information. It should be submitted. And so I'm going to order that the information that has been requested in the discovery request be provided within the next 30 days. I'll extend discovery for 30 days, and to the extent that it's provided, in the case will proceed accordingly. If not provided, then it will constitute an abandonment of the claim, and the court would entertain a motion for dismissal. It seems to me that there may that there may be a claim worth investigating here in the court being discovered here. But if plaintiff elects to not provide what I consider to be simple, straightforward information under the discovery request, then they'll abandon the claim. I don't see why we're here on this on the discovery issue, because the stuff that's been raised here is just not worth positioning this before the court in the context of a motion to compel. This is, for lack of a better way of putting it, it's common sense, reasonable discovery. And so I need to see this get done so that that this case is not bogged down here. So that's my order as it relates to the issues of discovery in this regard. What is your motion for summary disposition about, counsel?
Yes, Your Honor, and it does. A lot of it relies on the fact that this is the discovery was supposed to end, so the lack of information provided by plaintiff was a huge basis for this claim. And the city did file a reply brief. I'm not sure if it made its way to the court, but it is a good brief summary of the four main reasons the city is entitled to summary disposition. First is that they have there's absolutely no evidence that plaintiff has lawfully rendered medical services. This goes back to the medical license and the certificate of need, which are if they have them, then they should have provided them by now. They have the obligation to show that, and they merely.
Thank you.
Oh,
I'll take the motion under advisement, and I'll set the motion over for hearing on the next action date. It appears to me that to the extent that discovery issues get resolved in this matter, that the issues raised in the motion may be moved. If not, the court will pick up on whatever issues remain after the granting of the order to compel the discovery, as the court has previously indicated. So that information is to be provided within the next 30 days. I'm setting this matter over for a pretrial and motion hearing date, and it's going to be mid-October. That's going to be
10/19.
19.
Yeah, 10/19.
10/19.
Your Honor, may I address the court again one more time?
Just 10/19 at 9:45 a.m. Is the next action date on this matter. The motion is taken under advisement, and the motion for to compel is being granted under the terms as set forth by the court on the record. Mr. Jernigan, sir.
Sure, Your Honor. I know we're gonna discuss the MSD and the issues surrounding that at that date and time if they're still prevalent, but there is another issue I didn't raise regarding the motion to compel. I know you're saying they're investigating the claim. In my MSD, I didn't bring this up in the motion to compel because they don't, it's not something they asked for. However, the defendant, they did pay on this case. And the bill, the EOB that they said, it says the rates are based on blah, blah, blah. So they said that by paying, they admitted the only thing up to dispute is that the rates are reasonable. They already admitted that there's been an accident. That's what he's requesting, an accident report. He's requesting, like I said, the medical license. He's already admitted that those that was lawfully done by making those payments. Like I said, the only thing up to dispute is the rates, the value of the rates. By the EOBs, they've already admitted that. That's what it says specifically on the EOB that they provided. Like I said, you already made your ruling on the motion to compel. So I guess I need clarification. I'm supposed to produce everything that they asked for. And if my client is not in possession of that, I just let that be known.
Mr. Michaels, yeah, I think that's what you need to do, counsel. And to the extent that there is something wherein there has already been a determination, that I think in your answer to any inquiry in that regard, you would make reference to. I would think you make reference to the fact that the city has that information based upon their previous inquiry or whatever it was.
And I did, Your Honor. Sorry, not to cut you off. That's why I said I tried to work this out with Mr. Michaels, and I did let him know that. And like I said, they have that information. However, he also addressed that issue in his supplemental response. So he's aware of that issue as well. So that's why I said I think they're, as far as what issues are at stake, I would disagree, but you've already ruled on that.
Thank you, sir. Mr. Michaels.
Yeah, just to respond, I know the court's setting out the date, and it's probably best to fully address it then. The city never conceded. They have a certain number of days they have to respond. They did make some payments for some of the dates. I believe there is still one that's outstanding. I'm not sure though, because the complaint doesn't reference which dates of service are at issue. But also it would be important to note that on the payment, it says this is in full accord and satisfaction. So if he's saying that the payment concedes that those issues are settled, that it also should concede that all issues are settled. But of course, this court indicated it will hear that motion at a later time. I think it's a little premature to say that by making a payment, the city has now conceded that their services were lawfully rendered, when that's not true. That we just didn't have enough information at the time to reject it. That they still have an obligation to lawfully render it. They still have an obligation to charge a reasonable rate. So, and to show the other elements of the no fault statute. So I think at this time it's premature to rule on that the cities can. And also they cite no case law, the idea that payment of any service renders all of the issues definitively resolved. These payments could have been obtained with fraud. We don't know yet at this point because they haven't provided any discovery. So the city should not be precluded from arguing against these arguing that there's fraud, or arguing that it's not lawfully rendered, or arguing any element just because we paid one at some point. I think 3 at some point.
I agree, Your Honor. It's premature to argue this motion right now because fraud is very specific defense. So you need to state the specific facts for fraud, which they did not. In this case, it's a fishing expedition. As regards to the court and satisfaction argument he brought up as well, it's not that our client endorsed the check and signed off on it. It's automatically deposited in their check into their checking account. So they have no choice whether to accept it by the terms that are simply written on it. And like I said, Your Honor, on the date of this, I will have case law that goes directly on point with what I'm bringing up. If you want to, continue to hear that, or I can continue to argue right now, Your Honor.
I think that all of this is making for a big day on 10/19. And I'm being a bit facetious by saying that. Let's get the discovery issues drilled down. Sometimes discovery involves duplicating information. I mean, I think that we all know that, but you still got to go past steps 1 and 2, so to speak, to get to point number 3. And so I'll take the motions under advisement at this point, except as it relates to the discovery issue, and I'll address any remaining issues at that time. Let's close out the discovery challenges, and then I'll address your summary disposition issues at the next action date.
And Your Honor, would you like the parties to submit the order, or is the court submitting its own order?
Please, if you would go ahead and submit an order, and you can submit that to the email address I gave earlier. Let me just make sure you have it.
Yeah, it was Latifah Hunter. Yes. And I just want to make sure I spelled Latifah right. It's Latifah.
Yes.
Okay. All right. I will.
Make sure you put the dot, Latifah.Hunter.
Oh, okay. Thank you, Your Honor.
Thank you, Mr. Jernigan. Good day to the two of you.
Thank you, Your Honor.
Thank you.
Good day.
Right, this is case number 22-184-872. This is Discover Bank versus Joe A. Morris Tuff, Turf, T-U-F-T, is that last name there? Matter is before the court, set on for pretrial, and I do see that there is a motion for summary disposition regarding this matter. Your appearance for the plaintiff at this time, please.
Good morning, Your Honor. For the record, William Saloom, P41487, appearing on behalf of plaintiff.
Thank you, Mr. Solomon. Good morning to you, sir. Do I have Joe Morris Tuff on the Zoom? If you're here, please say something at this time. Right. I did receive, of course, an answer provided by Mr. Tuff. A Turf, I should indicate, and it basically are general statements in response to the complaint in this matter. Counsel, have you had any opportunity to talk with Mr. Turf recently regarding this matter?
No, I haven't, Your Honor. We did, as the court noted, the answer to the complaint does basically acknowledge these several paragraphs and leave to proofs the rest. It doesn't create a tribal issue for the court, which is why we filed the motion for summary disposition. I don't think we received an answer to the actual motion. I don't know if the court has one.
And that was what was on the tip of my tongue as well, is that I don't see a response to the motion in this matter.
Yeah, we don't have one either, Your Honor. Your Honor, I guess I would ask the court to enter the motion for summary disposition based on, tribal issue of fact for the court, as well as, I guess, the non-appearance of defendant.
All right, the record should reflect the defendant has not appeared. The court has made inquiry. The matter was set on earlier. The defendant simply has not appeared. I have reviewed the motion and the answer to the complaint. There does not appear to be a genuine issue of material fact in this matter. It does not seem to be a defense that has been raised to the claim in this matter. Accordingly, the defendant would be entitled under the applicable court rules to a grant of the motion for summary disposition. And I will grant the motion at this time. And judgment will be entered in this matter on the motion for summary disposition. Again, the court does note the non-appearance, but again, given that the defendant has responded to the complaint, the response to the complaint doesn't raise any issues that would defend against the claim that has been brought. And that is specifically what the motion for summary disposition addresses. The motion will be granted and the judgment will be entered based upon the motion. I do have a copy of the judgment submitted by counsel, and I'm entering that judgment at this time.
Thank you, Your Honor.
For summary disposition, so ordered at this time.
Thank you, Your Honor.
Thank you. Good day to you, counsel.
Good day, Judge.
Good morning, Judge Coleman. Good morning. My name is Monique Teal. I had to fight because they had bonded it over from small claim to civil, so I was just trying to check in.
What are you talking about, ma'am?
I think she's the last case. I think she's Thomas.
Oh, yeah, I haven't called your case yet, right?
Oh, okay. I just wanted y'all to know I was here. That's all, because I came in late. I apologize.
That's no problem. It'd be strange to me when people start talking, I haven't called the case, because I don't know what you're talking about. Let me get to the case and I'll deal with it there.
I apologize.
No, not a problem, man. I am calling now, case number 22-185-143. This is Progressive Michigan Insurance Company versus Nanetta Thomas. The matter is before the court, set on for a pretrial conference. Well, actually, a status conference. This is the first hearing, it looks like, regarding this matter. Your appearance for Progressive Insurance at this time, counsel.
Good morning, Your Honor. Tiffany Williams on behalf of Progressive, P number 74809 for the record.
All right, Ms. Williams, good morning to you, ma'am. All right, so do I have Nanetta Thomas on the Zoom, Ms. Thomas? I see Ms. Teal, but I don't see Ms. Thomas.
She's present by phone, Your Honor.
All right, say something to me, Ms. Thomas. Ms. Thomas?
Nanetta Thomas here.
All right, good morning to you, Ms. Thomas. All right, so counsel, tell me something about this. I see the answer, it looks like pretty much agreement with some of the stuff and then disagree with others. It seems that the defendant is saying that she had other insurance. Talk to me, counsel, update.
Yes, Your Honor. So this is a subrogation action, part of which we allege that the defendant was uninsured for the date of the accident. We received her answer and we see that she indicated she had insurance. We sent a letter to Nationwide. Make sure I say the right insurance company. We haven't received any response. So to date, we're not able to confirm if she had insurance. I know she's alleging she did. If she did, then she probably would need to file a claim with her insurance company. And I'm sorry, it's Liberty Mutual. The letter went to Liberty Mutual, Your Honor. I apologize.
I see that in the proposed or in the answer, yes.
So we
you haven't received.
no, I'm sorry, Your Honor. No.
Yeah, you haven't received any response on the Liberty Mutual inquiry. And let me ask you, Ms. Thomas, have you submitted any paperwork that you received from Progressive? Have you submitted that to Liberty Mutual?
Yes, I have. And Liberty Mutual has stated that they tried to get in touch with the people because we did have insurance with Liberty Mutual. They said they're not responding back to them.
I'm
The
the only
lawyers.
attorney on the file, so I haven't received anything. So I'm not sure. Definitely hasn't been anything sent to my email, and there's no voicemail for me. I'm not sure if they tried calling somewhere else.
All right, and,
I'm not sure either. I gave it.
all right, Ms. Thomas, do you have some contact information for the persons that you're talking with at Liberty Mutual?
Yes, we do. Hold on one moment. We're gonna get it out.
Well, yeah, I'm gonna have you to speak with Ms. Williams in a breakout room to convey that information. And what I want to do is set this over for 2 weeks, bring it right back, just to take a review as to what may have happened or may not have happened by that time. So I'm gonna set that date out for September. It'll be a little control date.
Okay, we can only hear you, so we can't see you. However, we do have paperwork, bank statements saying that we paid the checks like each month, saying that we paid for the insurance and the policy.
All right,
Oh, I'm
go ahead,
sorry. I'm so sorry, Your Honor. No, go ahead. And I was just going to respond to.
Yeah, I want you to go ahead, Ms. Williams, if you will.
Yes, so we can't take proofs of payments or anything like that because we don't get in the position of confirming whether Liberty is going to afford coverage for accident or not. So the person we would need to speak to would be an adjuster. So if a claim was set up, there's going to be an adjuster for Liberty and a claim number. And then that's the person who would confirm coverage. So not an agent, but an actual adjuster. And that's the person who determines if they would afford liability coverage, they being Liberty.
Right, Ms. Thomas. Yeah, Ms. Thomas, you were saying that someone had contacted you or that you had spoken with someone regarding this claim. So that's
Yes.
do you have information regarding that person that you spoke with that you can share with Ms. Okay, so I'm going to put you in a breakout room. The next date, and this is going to be the 20th of September. So I'm going to set it for the 20th of September at 9:30 a.m.
Okay, and it would be another Zoom. It'll be another Zoom call because we actually went down to the courtroom to find out what a Zoom call was all about.
Got you. So it will be a Zoom call. So you'll dial in just like you dialed in today on the 20th.
Okay, how am I able to see? Because all I can do is hear.
Well, you have to talk with your device experts to find that out. Well, somehow on your device, it has somewhere where you can activate the camera.
Okay, so do we have to download the app or something first?
I don't know.
She does.
Okay.
Yeah. Some people around me told me that you do. You got to download.
Okay, so that's what the problem was. We did not download the app, but I will for the next meeting.
Okay.
But hopefully they will get this taken care of prior to having another meeting, because my husband took off work in order to do this because I'm not computer savvy or phone savvy, so hopefully they can get in touch with Liberty Mutual.
Yeah, but that's not only their responsibility, that's yours too. You're being sued, so it's not on them.
Right.
It's on, and it's on both sides here, okay? So I'm gonna put you in a breakout with Ms. Williams, and then you're receiving a notification from me now. And once you receive that, just click in, and then you'll be able to exchange that information. And on the 20th, we'll see where everything is in this case. All right, I wish you well.
Thank you. And just for confirmation, we do not need to come back into the courtroom today, correct?
Exactly right.
Okay, thank you, Your Honor. Have a great day.
You too. Just one moment. So Miss Teal, what case are you on, ma'am?
Monique Till versus Mo's Auto Tech.
Advance. She doesn't have a court date for today.
Oh yeah, Advanced Auto Tech.
Okay, yeah, you don't have a court date with me today.
That came from, it was a small claims case prior to this, and they switched it over here and put the date out, but they didn't give it to us. They interviewed.
Right, and I had to, that's what I was saying, I had to find you because I had went into the Zoom from a small claims and they told me that it had came over to Silver, so that's why I came in, because I didn't want you to think I was late.
From the,
Hold on one second, what you said?
she had a lack of service from the civil case. So he adjourned it to today, but she switched it over here.
All right. So did you ever get that other party served in this matter?
Yes, sir.
All right, so what we're gonna do is we're gonna set up, I'm gonna set up a hearing date on this, because it's not set for hearing today. So we're gonna give you a date. We're gonna give you a date right now for the next hearing date.
Okay, thank you.
So,
5, 10, 12, 10, 12.
the 12th. October the 12th is gonna be your hearing date on this matter, ma'am. October
Okay.
12th, 10 o'clock a.m.
Okay, is it possible that I can get the Zoom number so I can just go, because I had to go on the website in order to get a hold to you.
Yeah, no problem, ma'am. So the way that you go about it is 360
Mm-hmm.
336 0000. So
Okay, thank you. October the 12th, 10 o'clock.
10 o'clock a.m., ma'am.
All right, thank you.
All right, I wish you.
I submitted the documents to the other judge, so I'm gonna be submitting it to you now that I know you're my judge.
Oh, yeah.
So hopefully you see it.
Yeah, you have to bring your proof and submit it to the court here, okay? So
Okay,
just come into the
so
Zoom and bring.
that online thing, that don't work?
Yeah. You submit it through the portal.
Yes.
That works. Yeah.
Okay.
Okay.
All right. Thank you. You have a great day.
All right. You have a great day as well, ma'am. I wish you well. Bye-bye now.
Bye-bye.